Okay, so welcome everyone. Good afternoon. And my name is Renee Bourgeois, and I'm the Executive Director at the John Humphrey Centre for Peace and Human Rights. I usually don't share my title because I don't think it matters, because we don't really operate as a hierarchical organization at all. But we're super excited to have you here today. And I'm just going to kind of open us up with the land acknowledgement and then pass on along, but also introduce us into this space. So I just wanted to start with the John Humphrey Centre for Peace and Human Rights is this kind of amorphous organization that many maybe hear about, but don't maybe know who we are. And I just wanted to add a little piece about who we are. So the John Humphrey Centre is really a legacy of John Peters Humphrey, who was the principal drafter of the Universal Declaration of Human Rights. And in his legacy, along with Gerald L. Gull, who had the Order of Canada, was a professor of law at the U of A for 38 years before he left us in 2012. Really, JHC exists to make human rights part of our local realities, our daily discussions, trying to actualize them at a local level. So we work to take these universal, interconnected, and interdependent principles, which became enshrined within the International Bill of Rights in 1966, and we really work to advance dignity, freedom, justice, and security through collaborative relationships and transformative education on peace and human rights. So it's from these universal principles that we need to be consistently reflecting on, as well as building our localized relationships in order to support our community to be a place where all are valued, participate, and belong. So in recognition of international human rights laws, we want to ground ourselves remembering how our human rights are deeply connected to the space we exist within, the spaces we take up every day, and who has access and who does not. We all know about the overrepresentation of Indigenous peoples in Canada in our prisons. We all know the history of an education system that sought to erase Indigenous history, culture, and identity and spirit. We all know about missing and murdered Indigenous peoples here on this land, and it still continues to this day. Part of doing human rights work in Canada is to recognize that we stand here on Indigenous lands, and here I stand in Amiskwaciwâskahikan in Treaty 6 territory. And what this means is we must recognize the history of law in Canada as well, and how it's evolved. We must recognize these original treaties as our starting point. So I just want to start by acknowledging the Indigenous peoples who've gathered, traveled, and taken care of this territory for thousands of years and continue today. We recognize the Cree, the Blackfoot, and the many First Nations, the Métis, the Inuit, who continue to courageously fight against dispossession, indifference, and oppression every day. And we have a responsibility to learn and honor these stories. And we accept that the treaties represent broken promises and continual colonial oppression for many. So we choose to reflect on the underlying intent of these treaties, which at their heart are about good relationships, nation-to-nation agreements that outline interactions of respect and reciprocity in our relationships with people and each other, but also the land, the water, and the animals. So we need to be centering together, grounding and decolonizing together. And for it is through the journey of walking together that we can correct this oppression and the oppression of others in our country who are invisible and struggling. For it is here at the heart that we can transition our countries and communities to truly come out of that history of genocide, the pandemic, and the increasing climate change. And it's imperative that we center ourselves together through the discomforts and struggles. And our intention here, and we're so honored to have you all here today, our special guest. I'm just really excited, and one of our newest board members, because, this is really to build a legal network, a strong legal network willing to push the margins a bit and to work to embed human rights into our legal systems. I think there's a false understanding that it is embedded, and I don't believe it is. So we have our foundations in the Charter, we have our foundations in the constitutions and in our treaties. And I just really am excited about the conversation and our capacity to, see the legal field as something where we can innovate and shift. And I'm just really excited to have you all. So may today be a good day. And I will pass it over to my colleague, Parveen. Thank you, Parveen.
Thank you, Renee. And thank you to everyone for joining us today. For those of you who don't know me, my name is Parveen, and I'm a human rights officer with JHC as well as a lawyer. And I do think that the conversation we aim to have today is incredibly important. So I thank all of you for taking time out of your Saturday to join us. So I just want to talk a little bit about what brought us here. So since 2016, JHC has been actively working to support people that come to our organization and who have experienced human rights violations. And in collaboration with the Alberta Hate Crimes Committee, we've become really a point of contact for cases coming to them that needed advocacy support. So there are a lot of intense cases that come into our organization that underpin the deep systemic discrimination and exclusion that exists in our society, but also the deep roots of intolerance among people in our community. And these cases range from hate perpetrated by individuals, but also what we would call hate perpetrated by state agencies. These cases are coming from some of the most marginalized in our communities, particularly Indigenous community members. And we know that hate perpetrates other communities, such as people with disabilities, which is very rarely looked at as hate. And our interpretations of hate is prefaced upon our lived experience. And I do want to mention that there have been a number of hate crimes, specifically in Alberta, that are a great cause for concern lately. So whether that's the numerous assaults on Black Muslim women in Edmonton, the defacing and vandalizing of gurdwaras, mosques, and synagogues in Edmonton and Calgary, the wave of anti-Asian hate crimes in Canada due to scapegoating for the pandemic, or the hate crimes perpetrated against the Indigenous community for simply existing. So our goal with this gathering is that one of our greatest barriers to supporting many of these individuals is not having access or connections to legal professionals working in this area. And most of these individuals are already marginalized and do not have the financial resources to hire lawyers. And as we know, access to justice really is a privilege that many cannot afford. And we've tried using human rights mechanisms to address these issues. And it is working in some cases, which does give us hope. But what we realize, however, is what we need is to create a network of lawyers and legal professionals and advocates who can not only work on cases, but who can work and push through on these cases and innovate within the legal field around addressing hate. And we do appreciate, the support of the Government of Canada to allow us an opportunity to start this conversation and to build connections. So with that in mind, I would like to introduce our speakers or discussants for this session. We have 4 incredible advocates and lawyers who have agreed to speak with us today: Lisa Weber, Robert Lee, Armand Chuck, and Jeffrey Westman. And just for the format of the session, we're going to have 3 rounds among our invited guests, followed by an opening of the floor to the other lawyers and then to the broader audience. So we do invite your comments in the chat, and Renee will be monitoring, so you may also direct message her as well if that's what you prefer. So I will ask our discussants to introduce themselves then. If Lisa, you would maybe like to go ahead and introduce yourself.
Sure, thank you. Good afternoon, everyone. And yes, I do have a cat who's trying to get in the picture. So in the spirit of Zoom on Saturday, we're both here. But thank you for the opportunity to participate in today's discussion. The invitation came to me quite recently, so you'll excuse me if I'm not completely prepared for the discussion, but I am a lawyer practicing throughout Alberta, and although perhaps not intentionally a quote unquote practice area as that's conventionally known, it has unfortunately been my experience that more often than not, the issues that exactly you just described are part of those struggles. So again, just very happy to be here today and very interested in networking and hearing what everyone else's experiences are too. Thank you.
Thank you for that, Lisa. Armand, would you like to introduce yourself?
Yeah, of course. I'm really happy to be here. And for me, I can tell you my background is in human rights. I after a few years of doing legal aid work for family law, I joined the Human Rights Commission. I was there for 12 years. In that amazing 12 years, I saw the A to Z of human rights, as well as working with amazing institutions like John Humphrey's. Professor Gall was my professor in undergrad, and as well as at the U of A Law School. He was more than just an advocate or he was completely engulfed with all types of human rights issues. His organization has, I think, been the leader in terms of making sure that we network, and we not only just network people, but we actually network ideas and then move forward with actually those people being more and more involved. That's why I'll always be available. I've taught workshops, I've given seminars, obviously I've prosecuted human rights violations. In my private practice now for the last 6 years, I do a lot of pro bono work. I try to make sure that the people that come to me at least understand the current status quo of human rights administration. It has its ups, it has its downs, but if we keep on pushing the envelope, like we just heard from Parveen, I think we're going to get there. I really want to share Renee's comment about human rights. I think from my 20 years of working in the area is not embedded in our society. It is absolutely not embedded. I think for the topic of today, you will realize that our institutions, they want to maintain the status quo that victims will have very little access to justice, period. And so I think that when we recognize that, we're going to be way more aggressive in our approaches. So I think that, I'm happy to be here, but we have a wonderful agenda. I'd want people to engage and work towards this is just another step in 1,000 more steps that are to come, and 1,000 steps that we've taken already.
Yes, absolutely, Armand. I agree with you. And I hope that, at least through having this dialogue, we can continue to take, another step forward. But I agree with you. We have a very long ways to go. So Robert, would you like to introduce yourself to the group?
Sure, thanks, Parveen. My name is Robert Lee. So I am a lawyer. I graduated from law school in 1989 and began practicing in 1990. And probably in the mid 90s to the late 90s, I started to focus on victims' rights, victims of sexual assault, and that's morphed into victims of child welfare is the predominant area of my practice. And the area of my practice is with regard to civil litigation. And I would say in the area of civil litigation that there is virtually no legal access to justice with regard to civil rights for victims of hate, victims of violence. And unfortunately, I agree with Armand where he just stated that our system is based on preserving the status quo, not on changing the status quo. And so that's the main and biggest obstacle that we face. And I'd have to say that over the last 20, 25 years of doing this kind of work, I have seen some progress, but not a lot of progress. And I think it's gonna turn simply with the change of attitudes of people graduating from law school who have more progressive views on equality and fairness, and having those people put into positions of power. So it's a long haul.
Thank you, Robert. And for our last discussant, Jeffrey, if you could please introduce yourself.
My name's Jeffrey Westman. So I guess my involvement, I've been a police officer for almost 13 years now. I'm currently working as legal counsel at the police service. So a lot of my experience in this sort of realm is either in investigating hate crimes or hate incidents at the sort of criminal point of intake or the criminal allegation, and then trying to connect people with alternative forms of complaint if either the threshold isn't met or if for whatever reason they want to proceed with a less, I don't know, try going some other route other than criminal. So I think that's about it. Oh, and sorry, I'm here as an individual. Human rights and these sorts of things are of incredible importance to me. I used to sit on the EPS's Sexual Minorities Liaison Committee, which received a lot of concerns from the LGBTQ plus community with respect to hate crimes and hate incidents. So I bring that perspective as well. And and my pronouns are he, him. They usually show up. I don't know why they're not showing up now. So just thought I'd mention that now too.
Sorry about that, Jeffrey. For some reason, we were mentioning earlier, whenever someone came into the discussion, they would show up as Nexi. So I'm not sure if, I don't know. I think it's just been messing with everyone's names, how they're displayed. So our apologies for that, Jeffrey. So thank you for introducing yourselves. And now we'll move into the first roundtable of discussion, which is the topic is how to really effectively support victims of hate crimes and how to improve access to justice. So I know that's a really big, meaty topic. I would like to ask Lisa to speak first, as I do know that she has to leave around 2. So briefly, if you could just describe what your experience is in providing legal or other support to victims of hate-motivated crimes or incidents, and what do you really see as the main barriers to effectively supporting victims of hate-motivated crimes or incidents?
Yeah. It is a lot, but you know what, I'm suspecting, and I'm really pleased to meet everybody, by the way. I haven't typically been involved with the society, nor with those who may be practicing explicitly in the area of human rights. But as I said, like, I find it like just implicit in the work I do that these issues are so common. So what I think of when I think of the question, I think a lot of people know that I'm going to use one of the cases I was involved in fairly recently, and it was very high profile. In any event, that case really just confirmed to me what some of the challenges were. So I was involved representing the Institute for the Advancement of Aboriginal Women starting in 2016, I believe, regarding the, at that time, the acquittal of Bradley Barton for the murder of Cindy Gladue. So I stayed with that case on a pro bono basis from 2016 until February 2021, when finally the retrial of Mr. Barton concluded. And so the first answer to that question, I'll say, and I hate to make this about money, but I mean, to be honest, that's a huge factor. So that was entirely pro bono for 5 years at the Court of Appeal, at the Supreme Court of Canada, and then for 6 weeks again at the Court of Queen's Bench in Alberta for the purpose of the retrial. And really, I have to say, but for the complete persistent motivation on the part of the organization that I've been involved with, also on a pro bono basis, as well as myself as an Indigenous woman. I was not going to let that go. There would not have been the follow through or the stick withedness, if you will, to stay in that arena. So there was no financial support for that. Which is a factor. So I identify that as a huge barrier. The other barrier I'll just speak about, and it is very specific to the current legislative framework, is early on in the retrial of Mr. Barton, I sought status on behalf of the surviving mother to participate as the surviving mother. And I cited the Canadian Victims' Bill of Rights as the mechanism to do so. And that application was declined by the justice. I think there was recognition on his part that perhaps in principle, it might make sense for the mother to have standing. But in essence, he said, my hands are tied. I didn't draft the legislation, and it clearly doesn't allow for the surviving mother to participate. And so that would be another barrier. It's the legislative framework within which we are having to try to move this bar forward. And so I don't know the answer, but I know, Robert Lee, I know we don't know each other personally, but I completely agree with your comment about there being no mechanism, and you use civil litigation as the avenue. I would agree, like, until there's changes made in the law, and which needs people who are informed and motivated to persist in convincing the lawmakers to make those changes, that's going to continue to be a barrier. So I'd say right now, those are two significant barriers that I see affecting our ability to support victims. And then I just had some other commentary. I'll later get to it, just in regards to overall my observations of some of the factors as to why this type of discrimination and bottom line racism, in my opinion, continues to exist and resulting in victims. So thank you.
Thank you, Lisa. And the third question as well was, and I know you touched briefly as well upon this, is how can we improve access to justice for victims and survivors of hate crimes in Alberta?
Okay, thank you. Sorry, thanks for the reminder. So I think there needs to be explicitly mechanisms to provide for that voice, because it's not happening. As you say, the status quo is not to allow for change, it's to maintain the system as it is, and there simply is not opportunity, in my opinion, for within the existing structure. So there needs to be change to those mechanisms. I think it does need to be at the level of legislation. And if not, in the interim, there's a lot that can be done through policy. And so again, it goes back to motivation of, I would say, governments, and in the case of the justice system, that would be either provincial or the federal government, to setting aside resources for this, because otherwise, we're going to continue to see, there's a lot of, so many, I don't even know, certainly in my practice on an everyday basis, I would say we hear of and we deal with and we support mostly women, Indigenous women, who are experiencing racism. It's often covert, but if we don't deal with that, you're going to have these extreme cases where there are serious incidents of violence and death. And so I think there just needs to be motivation and commitment to resource those opportunities for involvement. I think there's definitely professionals out there and programs and organizations that want to and are supporting people who are experiencing this type of discrimination. And often they're doing it on the side of their desk. And that's further injustice, in my opinion.
Yes, absolutely, Lisa. Thank you for sharing your insights. I don't know if anyone would like to go next. I don't want to start calling, but Armand, if you would like to.
Oh yeah, for sure.
Perhaps share your insights.
Okay, so I think I'll start with the third question about, and when I've ever given a seminar and I've given a workshop, I kind of tell people the same thing all the time. Just file your complaint, right? As fast as possible, whenever possible, file your complaint. Now, to me, that's working within the current system, which by no means is it perfect, but it is a system, right? And so for me, I wanted to tell, and I really like what Lisa had to say about the voice. So for me, it's really about, and I've been working with this for the last decade. The last few years I was at the Human Rights Commission, I really felt that because of the enormity of the demand and the limited capacity, that we had to create a new type of forum. It could be more legally centered, it could be less legally centered, but what really needed to happen was that voice and that participation of the victim. Now, again, the theme that I'm going to repeat over and over again is that the system is actually geared towards creating more victims. It isn't meant to solve true equality, equity, discrimination. It was never designed for that purpose. And I'm, before law school, I'm a sociologist, so I have to tell you that the reality of our society in Canada, and I think we can only speak to the society that we grew up in, and that we understand how we were socialized. Now, many people don't take even the slightest bit of time to reflect, but ultimately, I'm very appreciative of the fact that I come from a racialized background in which I could understand as an outsider what the majority or the main philosophies that govern this society. And so as I engage as a lawyer or as a human rights advocate or as just a plain observer as a person of color, I really get a real awakening as to, oh, this is what's happening, not only to me, but others in similar positions. So I've always said this, that most times in many of the high level meetings that I've ever attended, I represent pretty much every other group. I'm the whether it's race, religion, sexual orientation, everything. I have to represent everybody. And it puts me in a bad situation because then everyone thinks that I'm always the naysayer, right? But I like that because it's like, I'm the diversity person, I'm the equality person. And again, the individuals that operate within the system, most of them don't understand the problem that they're trying to say they're tackling, right? So for me, I wanted to, anybody who's listening, these are the things that everybody has to do, and they can do this on their own, or they can do this with a friend, or they can do this with John Humphreys, or they can do this with a pro bono lawyer. So I have a few things that everyone should do, and it makes things really organized. So you have to document. So I don't care what people say about, oh, you really need to have a really good case or whatever. But first things first, document everything, right? Record it, write your own notes, write your own perspectives, get everything you can, talk to other people who are a witness or who something happened to them that was similar. You got to document what has happened to you, right? So, in human rights, we understand that, okay, what's the area that you're in, whether it's housing or servicing or employment or whatever you're saying is the area that you were affected. But every single protected person needs to understand that without documentation, we can't really tackle the problem. And there's multiple issues with that. And we talked about poverty, we talked about certain groups that have been marginalized, but really, there's no better tool that I could share at first is the ability to document. So the second part, which I kind of alluded to, is what I always say is file a complaint. I don't care what it is. File a complaint to the Human Rights Commission, provincial court, federal court, whatever, file it. I don't care if you type it up or write with a pencil or crayon or whatever. Just put the complaint in. And it's very important that we recognize the amount of people that are affected by each individual type of a human rights violation. It's very, very important. So, you document for yourself and then you file a complaint. So that is so important. And whether or not the body or the institution takes it on is an important part of us understanding the next part, which is someone always has to follow up. The follow-up is key to understand, well, how does the Human Rights Commission respond to a particular complaint? How does the provincial court or the Court of Queen's Bench or the federal court or the, now you mean occupational health and safety? And again, I've had very big conversations with big policy people who talk about, oh, now we're doing human rights. And then someone else says, oh, we're doing it too. And we're going to use antiquated notions of human rights. And then I'm like, wow, we're not, I don't want to say this too softly. We're going back in time. So with the follow-up, at least we understand what the institutions are doing or not doing, right? And again, there are other institutions that are helping people. That is the next part, is the networking. And I'm going to use these terms however you want to take them. It is, you have to start to connect with groups, with people who've suffered as much as you. You have to network and say, look, this is what's happening. And then it all becomes a part of our collective knowledge about what's happening in our society. Relying on academics or some other institutions sometimes becomes problematic because they start to understate the problem and then they give you some other spin, right? So other groups have other agendas, like to Robert's point about civil rights and civil litigation. No, there's no insurance body that is interested in human rights at all. There's no real larger policy initiative about really, ending the harm, the centuries harm to Indigenous women. There is no institution like that. That's a joke to even suggest it. But what does mean that we have to create, and I think, Parveen, to your point, we have to create new spaces. I tried to create a new space within the Human Rights Commission and Tribunal, but that was rejected during the last few years of my time there. And it became a problem for them to then, because they were so satisfied with the status quo. They do 100 cases, maybe a year, and they're like, oh, look at how good we're doing. And we got 100, imagine the surveys that if you look at the annual reports of any Human Rights Commission, their reports are so ridiculously skewed to just be to defend the institution. Like somehow their 1% more customer satisfaction means something for the thousands, if not millions of people who don't get their human rights respected and don't get any consideration for what happened to them. So it really leads us to some of the things that I want to say positive about. The current institutions have amazing people who have experience, and you can lead that to better mentoring. So mentoring is absolutely critical for you to understand what it is that the landscape of the human rights area that you're wishing to understand, or you're a victim of a particular human rights violation. So mentoring comes in, like obviously, all of the people here, I think, are excellent to be part of that mentoring network. And whether or not it's, what Jeffrey was talking about, his experience with the LGBTQ plus committees that he was on, that experience and understand, and he would have heard hundreds, if not thousands of events of incidences that would have, would form the part of his ability to share, as well as to then give us better opportunities to help the victims. And so again, so I've gone through a whole bunch of things, and then I'm going to go into what I think is the main part, the two main parts of what I would call the disruption that's necessary in our current systems. Is we need to advertise, market all of the above points. When you document, complain, follow up, network, and mentor, you need to advertise and market it. People need to see it. Social media, write a book, write an article. I don't go on the street and jump on a soapbox with the speakerphone. I don't care. Whatever you need to do, you need to advertise and market it. Like, I mean, go out and raise hell or whatever. I really feel that if you don't advertise, market, promote, go out there, you will not get people to be aware, right? Because what I believe has happened now, I was at the Will Awards 2 nights ago, which is the Women in Law Leadership Award for it's all over the country, but for Alberta, it was held, and you had some amazing, diverse winners of the awards who stressed the fact that the achievements of the when there is a victory for human rights, that does not get disseminated, and what does get disseminated. So it's interesting because the Lifetime Achievement Award was won by Madam Justice Ritu Kular, who gave a phenomenal description about she said 2 very interesting things. One that I'll start with the negative first. She says for her children and even herself, she didn't feel as much racial targeting as her son now has. So her 18-year-old son is more, she said, I didn't have it, my elder son didn't have it as much, but then it's my younger son who's seeing more. And so she stopped there, but I think her comment was about the fact that something is happening that's increasing the level of racism and discrimination. The other part, which was about her hopeful part of what is happening with the larger institutions, is that she started by talking about the description of the Iranian plane crash in which I believe 120 or 110 Canadians were on that plane. And she talked about the headlines and about how it showed how Canadians were recognizing the loss to all of us of those hyphenated Canadians. And it was very good. And then she says, and I think a lot of people weren't understanding what she was trying to say. And then she compared it with the 1984 Air India tragedy. And then she talked about the fact that in the Air India tragedy, all of the victims were they labeled those Canadians, those hyphenated Canadians, as Indian. And so that is the reality of how the larger institutions, be it media, be it the government, then starts to distinguish us as people of any diversity and say, well, we really don't need to put any resources to what's happening to you because we got better things to worry about us. So that exclusion is the reality that we have to recognize. And you just look at any of the higher management levels and higher like law firms and judiciary, it is still that there's a barrier that is actually, you can physically see that barrier. And from that barrier, you should recognize the systemic racism or systemic discrimination that exists. That, to be honest, I think everyone who's in those positions still wants them to exist. So I think that, for me, talking about how do we help victims, what I said first is that the work that I've done work where I have a very limited role to prosecute something. My goal is not to end gender discrimination in the big sense. It's to deal with a complaint that somehow survived our system, and then I am the fortunate one to then present it in a neat package to a tribunal and then deal with other, it could be a very strong reaction from the Respondents' Council, and sometimes it's no reaction, and we get some sort of resolution. And I'm not saying that's not a good thing. I think that it's a stepping stone. So to me, a Human Rights Commission, Human Rights Tribunal, those are stepping stones to something else, which I think all of us can build towards and have something a bit stronger. The United States has had several different approaches to having alternate legal systems in place for racial discrimination. Some work, some don't work. Some of it is really like, high, it's all policy, it's all politicized, civil rights movement. Some of it's about employment equity, and they've developed interesting ways in which we look at that. Obviously, we know now in the media, critical race theory has been discussed and demonized by the status quo, and they've really reframed it. And I was talking to a friend, and this will probably be my last point about this section, is that, so if you study the development of affirmative action policies, the counter movement started and still has this underlying discriminatory like a reaction where it labels it as reverse discrimination. And that is something that is very, very disturbing to see now with critical race theory. It's the exact same problem. Critical race theory has now been undermined by then referring to it as almost like anti-white racism. And again, I don't mind, I'm focusing on race just because I think it's relevant in the media and everything, but whether it's disability, sexual orientation, gender identity, whether it's race, religion, to be honest, I mean, I truly believe disability is probably one of the highest disregarded areas of human rights victimhood, right? I mean, those are victims who people pass on to the next institution, all the time, right? And their harm, the way they feel, it really is quite sad, because people always feel, oh yeah, we're doing enough for the people who have some disability, while other areas you may get people to get more active in. So I'm sorry, I might have taken a little bit more time than necessary, but I thought it was important to lay out what I think is good to effectively support victims and improve access to justice.
Thank you, Armand. You brought up a lot of points that I'm, thinking about and digesting, and I think we've been able to really identify, I think, a lot of what needs to be addressed. And I think even at JHC, we've had these discussions as well too, of how best to market and disseminate what's going on, and even the work that we are doing, as you were saying, get up on a soapbox and get people to notice what's going on. I think that's something that's a really crucial part of how to address these barriers. So thank you for that. I would like to ask Lisa just one more time if she has anything else she would like to add, because I'm just looking at the time, and I know you have to leave in 10 minutes. So I don't know if there's anything else that you would like to speak on.
Yeah, thank you very much. I really appreciate it, and I really wish I could stay for the rest of the day. But the only thing I really concur entirely with everything that Armand has shared. What I find myself thinking about in terms of documentation, when I think of the people that we deal with, that I deal with, certainly in my practice, whether it's an explicitly a case or whether it's implicitly through the organization that I volunteer with, is so documentation is absolutely key. And we can't presume either that those individuals have access to resources to, in fact, document. We see that, and so many of us take it for granted. I mean, I'll use an example, the QR code is an example. There's so many women who are contacting and expressing good grief, this assumes I have a cell phone, that I'm keeping the same cell phone, that I have access to the industry. You know what I mean? So it's those type of presumptions, which are also discriminatory. So I think that's definitely something that needs to be, considered. Other important point, I think, and again, thinking about the segment of the population that I mostly deal with, is the normalizing of the experience. It's so sad to hear and see women and girls, and that, like I said, that's mostly who I'm dealing with, is they don't even realize that it is a violation of basic human rights. It's become so normal to experience that type of discrimination and racism on an everyday basis. I don't know what the answer is, but I see that as a huge, huge problem as we move forward. I just wanted to speak very briefly on the bylaw, because I know that is next up on the agenda, and I apologize, I'm not going to be able to stay for that segment of the discussion. I did have a quick look, though, at the bylaw. What struck me most obviously, I mean, I commend, any government that takes steps to address these inherent challenges we have. My observation, though, is that the bylaw isn't explicit enough. If we're going to be dealing with hate crimes and addressing that, why not have explicitly a hate crimes bylaw? Call it what it is, because I see if we, pardon my colloquial terms, but if we pussyfoot around these issues, like you say, the status quo is going to continue. So call it what it is, say it what it is, commit to it, and don't mix it into an omnibus type of bylaw. That would be my suggestion regarding the bylaw. And like I say, I'm not intending to criticize the efforts that presumably were behind such a step, but I think we need to deal with this bang on, or things just are not going to change, and we're going to continue to see those very extreme examples of hate crimes committed, as well as the sort of the covert, and it's huge, the covert experiences of human rights violations and hate crimes is so prevalent in our society that's become normalized, and that's intolerable. So thank you, though, for the opportunity to share my final thoughts. I'll stay on for 5 more minutes because it's a very interesting conversation, and then I'll just sign off quietly. Thank you.
Thank you so much, Lisa, for joining us today. We really do appreciate your sharing your experience and insights. Robert, if you would like to go next with the first 3 questions.
Thanks, Parveen. I mean, this is a huge topic that we're trying to discuss in 2 hours. So I think that's very important to recognize. With regard to how to best help and support victims, it's a big question, and it's a question of whether it's a bottom-up process or a top-down process. So for people that work in organizations like John Humphrey, I think in your experience, it's probably more of a bottom-up type approach where you're dealing with the people. In my role as a lawyer, I view it more as a top-down approach. So the topic of the victims' rights, hate crimes rights, access to justice, to me, that is solely a legal issue. And so we have to focus on the legal system to solve that problem. Now, there's 2 main mechanisms where you could try to address these issues. And that is, number 1, getting government to change. And that would be maybe more of a grassroots type approach, trying to get people to elect people that believe in human rights. So that's one approach. The other approach is, with regard to the legal system, is the judiciary. The benefit, I think, of trying to attack the problem through the judiciary is that judicial appointments are for life, and judges have independence, and judges are not necessarily bound by the whims of the public, and judges have to follow the law, and the law as it stands does respect human rights. And therefore, I think that, in my view, the best approach is through the legal system. And that's the approach that I've been trying to take to help victims of crime and accessing justice. Sandra mentioned the other big problem in accessing the legal system is money. And so that is a huge access to justice problem. The victims generally don't have money, and it's very difficult to find lawyers willing to work on a pro bono basis or even on a contingency basis. Now, that's how I started doing this work, on the presumption that it could be done on a contingency basis. But through my 25 years of experience, I've discovered that the legal system as it exists, as it is practiced, allows the defendants to drag cases out too long, to make it too expensive, so that you are not really getting justice. You are not having access to justice in our current legal system, because it can just take too long. It can take 20, 30 years to finish a case, and lawyers cannot work for 20, 30 years without getting paid. So that is a big hurdle. So what I have done in my practice to try to address these issues is, number one, I have tried to make the defendants pay the legal fees. So most of my work is against the Alberta government, against child welfare. And so the mechanism I have used is advance costs, or it's called an Okanagan order. And that is where the judge can order the defendant to pay the legal fees of the injured party through the litigation. So that overcomes this problem of money. And I have had some success with it, and I have more cases coming. And if I'm successful in that, I might be able to create a precedent that forces the government, in almost all cases, to provide the funding to the victims in child welfare cases. And if I can accomplish that precedent, then it could be expanded into different types of situations, not just child welfare, but other types of victimization or other types of hate crimes. So money is a big problem. One of the things we looked at was, maybe getting legal aid to cover it, because legal aid will cover many human rights type issues in criminal proceedings, for example. People can get lawyers for that, but they can't get lawyers for the civil side. And that's a big gap in our system. So that's a gap that needs to be filled. And one way that I'm presently using is this idea of advance costs. The second way to support and help victims get access to justice is I've tried to use a mechanism of class actions. So rather than doing one case at a time, so if a lawyer is doing one pro bono case at a time, you can only help one person. By expanding this to a class action, I'm hoping that I'm going to be able to help tens of thousands of Indigenous victims of child welfare, and non-Indigenous victims of child welfare. Now, one of my cases, we were successful. We were successful at the Court of Queen's Bench. And interestingly enough, our legal system is so small. The justice that I had was Justice Grasser, and he was absolutely excellent in my case. Ironically, he's also the lawyer that was involved in Lisa's case, where he was the judge in the I'm forgetting the name of the case now, Lisa. Can you just?
Yeah, it's Barton, the Barton
Yes,
trial.
the
Yeah.
Barton case. And so I know he received some criticism in that case from the Court of Appeal. But my experience with Justice Grasser was that he was just absolutely excellent in my case. However, the government has more resources, and they appealed my case. So my case, we had a class definition that was children from 1985 to 2009 who did not have a service plan properly made for them. So my class action covered tens of thousands of people. Unfortunately, when it got to the Court of Appeal, the Court of Appeal decided that this specific representative plaintiff was a very narrowly defined group. And so the Court of Appeal said that, no, this case should not cover 1985 to 2009. It should only cover 2002 to 2004. So this went from maybe covering, 10,000 kids to maybe covering 10. It might even cover 5. Like I don't know how many kids are covered now that it's been narrowed so far. And what was very disappointing in that Court of Appeal decision, from my perspective, is that the Court of Appeal did not need to eliminate all of the other people, like from 1985 to 2002 and 2004 to 2009. All they had to do was say, we're going to make a separate class. So we're going to have a class from 02 to 04, and the rest will be in a separate class because they got some different issues. But they chose not to. And the interesting thing is, in class action litigation, it's about what is the best procedure to go forward. So in that decision, the Court of Appeal decided that it would be best for the children from 2002 to 2004 to go ahead with their case as a class action without the other people. Now, that's absolutely legitimate. That's a very good argument for those people from 02 to 04. But then what about the other 9,000 people, the people from 85 to 02 and 04 to 09? So then they decided, the Court of Appeal decided they don't get a class action. So what that meant is they lost all access to justice completely. And the Court of Appeal decision was, well, they should just go ahead with individual actions. And we had already demonstrated to Justice Grasser that there are no lawyers that are going to help 9,000 people with individual actions. And from my perspective, the court itself does not have the manpower to take on 9,000 cases of children claiming that child welfare didn't do a proper service plan for them. If 9,000 children did that, or 9,000 former children did that, you do not have enough judges to hear those cases. And so that to me was a very disappointing decision that to me was a complete denial of access to justice for those people. Now, so how do we get around that problem? So that's a huge problem. The Court of Appeal just got rid of, 9,000 people's lawsuits, just like that, with the, signature. So what I did was, okay, Court of Appeal, you say it's not proper for those people to be in the same class action with the kids from 02 to 04. So I'm just going to start a new one. We'll just start a new one for all the people from 85 to 02 and 04 to 09. They have the same issue. We already proved that there's more than one. We met all the criteria already. The only thing the Court of Appeal said was, well, but it's not good for the 02 to 04 people. Okay, we're going to have 2 class actions then. And so I started another one up. All together, we're going through the issue of trying to get advanced costs again. And so, but this shows how our system is so flawed, because it took us 10 years to win that first decision. And now we got to do it again. Like, what a waste of time. And the Court of Appeals decision was, well, this is the most efficient, effective way to use our court research. How can you tell me that, because I'm the one doing it. How is it efficient for me to do the exact same thing over? And the government lawyers are going to do it all over. And we have the same judge. Do we expect the judge is going to give a different decision after it's identical? I mean, so to me, it's mind-boggling to me. But that's my perspective as a minority person growing up in the system. And I realized just how there are different perspectives, and the status quo, they prefer the status quo and I'm not in the status quo. So I don't understand why they prefer that. From a logical perspective, for me, it doesn't make sense. I'm sure it does for them. I'm sure they're not doing it out of malice. But for some reason, they see things differently from the way I see things. And so as I said earlier, I think what's going to happen is, people growing up with attitudes more similar to mine have to get those high positions on the bench, on the Court of Appeal, and hopefully they will render decisions that are more similar to how I view things, how I see logic, and likely how most people sitting in here today see the logic. Now, barriers. Okay. I think the barriers are the attitudes that exist in the present system. So I'm going to tell you about a case that I have coming up on Tuesday. I had a victim of a gang rape, and she applied to the Crimes Compensation Board for compensation. And in her case, and I can talk about these details because they're in affidavits, so they're public, so I'm allowed to talk about them. And so in her case, she applied, and when you apply to the Crimes Compensation Board, the statute says you have to have a quorum of 3 people, or quorum of 2 people making the decision. So in this case, the chairman made a decision on his own. So that's not following the legislation. The second thing is he made his decision, and then afterwards he documented the reasons for his decision. And in that memo he wrote to the other board members, he wrote something to the effect of, I must confess. So he's using the word confess. So that's an admission of guilt right there. He's confessing. He says, I must confess I did this. And what he did was he gave a decision to give the victim a small amount of counseling. So he did that to get rid of the file. Those are his written words in black and white, to get rid of the file. So he gave her a little bit of money so that he would have given her something so that she really can't complain because he gave her something, and then he can get rid of the file. And then he adds, and because I assumed she wouldn't go for counseling in any event. Now, to me, that is an abuse of public office. Any tribunal decision maker, whether you are a judge, a board member, whether you're a teacher, if you are making a decision, you cannot make a decision because you want to get rid of the person. And so to me, this case is black and white. There's no doubt in my mind that this was improper and abuse of that person's power to my client. But when I go into court on Tuesday, I have no idea what the judge that I'm going to get is going to think, because he might think, oh, well, that's a high position. That person's a high position. He's a lawyer. He wouldn't do something like that. I mean, people in power, they don't mean to hurt, the little people. So, we can't believe his words. He really meant something else. Or he might say, you know what? This person's a lawyer. He's the board. He has the power to make these decisions. And if he thought it was appropriate because he wanted to get rid of this person, well, that's his right, because he's in that high position and he has the authority to make the decision. So it's difficult for me as a lawyer to go into that process where my idea of logic and rationalization might not be shared by the people I'm making my argument to. So I answered that one out of order, but those are my comments.
Thank you so much, Robert. So finally, Jeffrey, if you would like to share your insights and answer those 3 questions.
Thanks, Perveen. And I know Lisa isn't here, but it is really humbling to hear the experiences of council who are sort of in the trenches on some of these things, because I am a little bit removed in the sense my experience is mostly criminal and advising members, police officers on pre-charge considerations, investigative considerations, those sorts of things. So it is really interesting to hear those perspectives. So I guess, since on the basis that my experience is mostly is pretty much exclusively criminal in nature, you know, I can say that I'll sort of jump to the point on barriers. And so the typical trajectory of one of the I think it's fair to say, at least anecdotally from my perspective, typical trajectory of one of the complaints once they come into police is that they get investigated and usually classified as a hate incident rather than a hate crime. And that can frustrate people. So right off the bat, we're creating a barrier by telling people, well, you've called police. I know you think that we could help you, but we can't. And so this, there's really nothing that that we can do. And so that generates enormous frustration at the outset. Something our agency, I'm really proud of EPS for doing and continuing to work on, is trying to close the or make connections where we're not able to connect people. So, you know, the chief was just on the news and about you know, these help navigators and that sort of thing. So we have all sorts of systems where we're trying to connect vulnerable people with social networks where police can't help. And but that doesn't exist for this sort of realm of law, where you know, and it's been exacerbated by COVID. But I know that the other lawyers, Robert, Armand, Parveen, I know that you guys know that the courthouse is a disaster post-COVID. I get lost trying to navigate chambers, trying to navigate the clerk's desk. Like, COVID has just made things a disaster. So that has really exacerbated. I can't imagine. I often say to the people in the law library, I can't imagine how it just terrifying this process is for people who aren't trained to deal with it. Because here I am, I articled pre-COVID. And so I know sort of what the system looked like before. It wasn't a great system, but it worked. And now we have a system that really isn't working at all. You know, changing virtual courtrooms without telling counsel, you know, and you have no one to call. You can't call the clerk's desk. So anyways, those are, I think COVID has sort of generated these institutional barriers. I think access to justice has been, I know that that's been a hot topic during this conversation, but we used to refer people as police officers to the Law Information Center all the time. And that's no longer a thing. We used to be able to refer people to places like the Edmonton Community Legal Center and you know, pro bono organizations. But these places are often doing assessments of income and those sorts of things, and people are not qualifying. So again, that access to justice piece, these policy decisions, closing these organizations and these little niche social connectors, legal connectors, that's been a huge barrier as far as I can tell. So then once we're dealing with the member or dealing with the public who have made these complaints, a major, the two sort of obvious, I guess, barriers are the politicization of these hate crimes and hate incidents. People are reluctant to get involved in processes where they're going to be thrown into the spotlight or end up in the news. And that can happen either, you know, once they start telling members of their own community what's happened, they can sort of be involuntarily cast into that spotlight, right? And the common experience is either that people really lean into the spotlight or they really pull out of the spotlight. There's no in between. So we'll have people who either really want to use that spotlight to help shed light on the issues that they're facing, or we have people who completely withdraw, stop answering phone calls, stop wanting to participate in the investigation, that sort of thing, right? And then the second issue, of course, which is obvious, it's almost so trite that I shouldn't say it, but I will, that fear of police is a huge issue. You know, hate crimes are happening to people, occurring to individuals with lived experiences that generate their own barriers to just even approaching police. So regardless of how well we train and, you know, I think it was Armand brought up the idea of mentorship. You know, a lot of this work has to happen in the community itself, which is why I think we're so convinced that, you know, we really have to work in the communities to sort of build, start breaking down these barriers. So I think, not to dwell on the barriers too much, I am going to talk about maybe some solutions, but you know, policing and law practice, Robert talked about this, but policing and law practice are just both incredibly conservative. I don't know how I ended up in this profession, being of the political bent that I am, but they are just so incredibly conservative and just don't, by that I mean change comes so slowly, and it's like steering the Titanic away from the iceberg sometimes. You know, like you see these disasters happening and you just can't do anything quickly enough. And of course we see a lot of this conservative reality with the trials examining Ahmaud Arbery in the United States, and even the trial of Kyle Rittenhouse, right? We like to say that this is a different legal system, but it really isn't. These are our legal systems that the same legal systems that we're using. So I guess to solutions, again, speaking as an individual, as an officer who had to respond to concerns from the community when they're making hate crimes complaints, again, I think it's becoming pretty common practice for police officers to say, number one, we can't do anything because our mandate isn't engaged. But then number two, this is where you can go to sort of, this is your next step. So to try and close that loop, we don't have anything in this space to be able to connect people with, really, aside from the Hate Crimes Committee, Tiffany. But you know, we no longer have the Law Information Center. The law librarians at the law library are limited in what they're able to do. The ECLC and other pro bono organizations are strapped in terms of resources as well. So clearly identifying, I think, for us some resources and some opportunities to connect these people where the disconnect is happening. which is essentially, you know, we can't help you, but, you know, filling in that last part is really important. And I guess I can just speak to the second point, which is the bylaw, which I, again, going back to the conservative nature of law and policing, it maybe doesn't go as far as we would like it to, but I think this is a huge step forward in being able to equip our city to deal with hate incidents as well as hate crimes, right? So I think it is a good start. I think the bylaw as it is, again, sort of puts another tool in the tool belt. I know it's cliche analogy, but it's another tool out there for for police officers to use to address these sorts of issues. But yeah, do I wish it would have gone further? Yeah, but I'm also super excited that it's there. I'm super excited that it's coming down the pipe, and I think it's an excellent start. So yeah, and those are sorts of my comments. I did also say I appreciate, you know, I really appreciated being able to listen to Lisa's comments on Bradley Barton, and Robert, your comments on particularly with some of your litigation strategies, the Okanagan order and that sort of thing. I found really interesting. And then Armand, I really enjoyed listening to in particular your observations of Justice Couillard. I wasn't able to make the Will Awards, so but you're absolutely right when you say that the systems, we really have to have and build systems that are going to serve us and not just sort of rely on individual practice or the goodwill of lawyers. Because I've taken one pro bono file in my entire career. I thought it was all consuming. It took me, it was like a small claim, and it was nothing. These things are incredibly consuming. So to expect lawyers to be taking them on as a measure of goodwill is just impractical. I don't think people completely understand the work that these things have or it takes. So thank you so much for that.
Thank you so much, Jeffrey. I think you brought up a lot of excellent points, especially about strengthening and building institutions and that are able to better serve the public as well. And just for our participants, Lisa had previously, before she left, discussed the bylaw, and Jeffrey has as well too. It's the second roundtable discussion, which was the role of bylaws in hate-motivated harassment. So I posted it in the chat as well too. The City of Edmonton and Public Services Committee is considering a recently proposed bylaw amendment to address hate-motivated harassment in public places. So the bylaw amendment would add a prohibition of harassment based on race, religion, gender identity, sexual orientation, disability, and other grounds to the public places bylaw. So the question that I am posing to our discussants is this bylaw sufficient to address hate-related crimes? What gaps are not addressed, and which community should be consulted while developing the bylaw? So I'm not sure if Armand, would you like to go first? We can just go back.
Sure. Again. Yeah, no. So I did make a point earlier about institutions that have added a human rights element. So we know a couple of years ago, or maybe 3 years ago, occupational health and safety in the area of, obviously they operate in the area of employment, like work environment. They added in a human rights element, and I've seen it operate, and it doesn't really I mean, it doesn't really work, but I think I just want to come back to the question, is this bylaw sufficient? I mean, I think it's good to have a bylaw. I think it's always good to add. Like, I think that as long as the individuals creating the bylaw are linking to institutions and organizations, I think that's where we can add to any bylaw. I think bylaws, and I think it's to Jeffrey's point about, he has a lot of hope, and I think he's excited about it for good reason. I think we need to make it very specific. I think that's to Lisa's point. And ultimately, my only concern is that what I've seen with Occupational Health and Safety and the Law Society of Alberta, so the Law Society of Alberta has also started their own human rights and discrimination aspect of their regulations and rules for lawyers. So this City of Edmonton bylaw purports to then try to have a bylaw about hate-motivated harassment in public spaces, never really understanding that the opposite side, or the way that it gets adjudicated, or the way that people criticize it, has to be addressed like, we have to be really serious about what we're trying to achieve. And so when you go to the second part, what gaps are not addressed, we're really poor at dealing with remedies and resources. We're really poor with that. So it's that is like, there's no person in policy who actually has put their mind to providing a proper remedy and there's clearly not going to be enough resources. We're already strapped as it is. So to put something on paper which will never get implemented and is not really dealing with the problems that we know exist when you create another type of human rights body, within the municipality, within the Alberta government, within the Law Society, if it doesn't really meet a criteria to help a victim, and it's not even in the mindset of the creators of this. So I've been to these meetings, and it's like, some people, like, no joke, will say, well, what exactly is hate? What exactly is discrimination? And we spend months on that. And not to be too flippant about it, but I disengage. Like, I'm like, well, if you want me to go back to 1982, I'll go back to 1982. But I think that I'm really past that. So once you catch up to 2001, then I can re-engage. And I try to be as nice as possible about it, but it's hard to be that when you have people saying, well, what about those people who are just trying to express themselves? And it's like, yeah, by harming people and hating on people and threatening people, and and I think this is interesting where Jeffrey and his institution fits in, is that unless that institution is educated and has sensitivity to the fact that hate is real. Hate has existed from the creation of this post-colonial country, right? So that hate, we have to go back and say, look, we have to recognize that hate exists. We have to, it created laws, it created horrible policies, and it creates a really difficult, like, I have a difficulty following people who create human rights policies but don't even agree with the simplest concept of equality or equity or discrimination. So that's why I'm like, well, okay, I mean, if you're making the laws, if you're applying the laws, what can I expect for those victims who have a different life experience, right? And so we have to be careful about, like, we have to engage the bylaws. And again, I just want everyone to engage the process. Like, I don't want anyone to stop. I think that's my remedy, is engage. And it doesn't matter if we win for one or we win a class action, it's that we are engaging, right? To the third point, the bylaw also fails because it doesn't include the human rights organizations that have been doing this work. It doesn't have proper definitions. It does not want to deal with individual victims, really. It's structured so that it makes it look like they're doing something, but really the proof is going to be in how they present how the program is being implemented, enforced, and how does it help the victims who actually are look, I mean, this should protect people. But if people don't feel more protected, don't feel that the society we live in is going to be equal to them and will not tolerate that level of harm, that's when we have to take a stand against a policy like that and a bylaw like that, because then that means that it is perpetuating the status quo. And that is what you get in these discussions, is that the status, they like to present the status quo as, and you get some really bad commentary where people say, well, what more can we do? So it's like they're so uninspired. And again, so there's one thing you have to understand, that from a sociology perspective, most of law operates on a lie. The lie is that this is the best way that we can adjudicate people's complaints. That we know that to be a lie. And they say lies like, deterrence, which is a complete lie. Like, we make a law, it doesn't have a deterrent value if you don't have true enforcement. It doesn't have a deterrent value if you don't spread the harm. Like, if you see a harm, you have to target it. You have to say, this is a harmful thing. If you want to eliminate it, you have to start to do enforcement, which has significant consequences. An enforcement that is 4 years down the road, like, how they say justice delayed is justice denied. That is the reality we live in. But more than that, when you have a remedy, like to Robert's point about what the case that he's going through, when you have a remedy that's thrown out so that you can make it look like you're doing something, you're not really addressing the harm or the victim. What you're doing is you're saying, well, we have to do this so it looks like we're doing something. And many times I've told people, I said, well, look, I'd rather you do nothing than do that, because I think it gives people, especially people who don't believe in the bylaw, the false impression that, the city is doing so much and people are being ungrateful, right? So again, that level of discussion, and there's a lot of studies on the way in which the counter arguments are actually representations of the the voice of discrimination has this so-called academic arguments that get thrown at you. And then you look at this and say, wow, so for some people say, hey, what about that counter argument? And they almost walk over the victims and they then focus on the counter argument. So just be careful when we develop bylaws, any laws, that the implementation, the enforcement, and the remedies and resources necessary are implemented. So we have to speak out against those things, and hopefully, again, with our collectivity, we create a lot of strength.
Yes, absolutely, Armand. That just really struck me as well when you were saying our current legal system is based upon a lie, or at least just even the appearance of doing something without actually having that kind of implementation or that kind of accountability and transparency as well, enforcing it. So thank you for bringing up those points. Robert, I don't know if you would like to go next on the bylaw issue.
I'm going to be a little bit of a contrarian with regard to the bylaw. I agree in some ways with Armand when he says, as long as we're doing something that's a positive. And in some ways, I really agree with that. But the reason why I'm going to disagree with having this bylaw is because I think it then lessens the actual hate crime from being a criminal offense to making it a bylaw offense, and therefore diluting the seriousness of it. And so I've done a presentation where I explained how this kind of racism, making threats and swearing in public, can be a criminal offense of causing a disturbance. And there is case law. It's not just in the criminal code. There is case law where people have been charged with causing a disturbance for, just being offensive and loud and interrupting other people. And so that is something that is a crime, in my opinion. And so I think that in a way, adding this bylaw could be a good tool for police, because then the police could say, oh, well, okay, this is not a crime, but it fits this bylaw. And so therefore, we can charge under the bylaw. But then maybe the police will say, well, it's not my problems. I don't do bylaws. So we'll go find some bylaw officer to investigate and lay the charge, when really it is a criminal code offense. And I think that lessening the severity of the behavior to a municipal bylaw is counterproductive to our goals, because I think what I would prefer would be to see more training of police officers so that they understand that when a lot of these hate crimes occur, which they might call a hate incident, it actually fits the definition of causing a disturbance or mischief. And that's what I would prefer. So rather than spending the time on the bylaw, I would prefer just implementing the things that we actually have in place that cover it. So, and I have not read the details of the bylaw, but so my perspective is just kind of an overall perspective of, and I have the same perspective when we pass some, legislative laws, again, where it's a criminal code offense, which is federal. Don't minimize it. Don't bring it down in severity. It is a criminal code offense. We should treat it as a criminal code offense.
Thank you, Robert. That's an excellent point, that the bylaw then lessens the offense and minimizes really the harm that's happened to the victim, as Armand has pointed out in the comments as well too. Jeffrey, I don't know if you have anything else you would like to add about the bylaw question. I know you spoke about it briefly.
No, I just wanted to acknowledge Robert's comments is completely valid. Yeah, it's you're absolutely right. Things like causing a disturbance, mischief, framing mischief as the interference of a person's right to enjoy a place. Absolutely, those are legitimate ways to frame these issues. I think that the thing that the bylaw does do well is, I guess, again, in terms of and the point on police training is well taken as well. Speaking as an individual and not as counsel for the police, but I know that training and mentorship and development of our members and honing their sense when they are exercising their discretion. These are issues of public importance and things that we have to. I know that there's consensus that we need to continue doing. In terms of the bylaw, we often see some things, I guess. No, do you know what? I won't comment on that. I think the point is well made by Robert, particularly with respect to the idea, and I might be oversimplifying it, but a police officer arrives, sees, has reasonable grounds to believe that an offense has been committed, but says, well, this is a lesser offense, so I'm going to write a bylaw ticket instead. So that point is well taken, and I think that there is some validity to that. So thank you. That was a long-winded way of saying I don't disagree with you, Robert.
Thank you, Jeffrey. And now we'll move into our final roundtable, building a network of legal professionals. So how can you realistically imagine a network of legal professionals working to provide legal and human rights assistance to victims of hate-motivated crimes or incidents? And although this is a bit obvious, but really what would be the benefit of developing such a network? So Armand, if you would like to go first.
Yeah, I wanted to, but I thought, oh, I didn't want to seem too anxious to come in. I think, one of the things that I think that I kind of started with is, and I think I'm going to, make sure that everybody understands that what I've been working with probably since 2000 and at least 2009. So 2007, I had got my LLM, and my major paper was on human rights institutions. And I tried to figure out within our current regulatory framework, what could be done to enhance the understanding and the protection and the enforcement, and then the remedies that people would be entitled to. And honestly, I could tell you 1,000 stories about good parts of human rights, but I can tell you probably 100,000 stories of bad parts of human rights. So there's no doubt in my mind that we need a network of legal professionals, and some who agree on process, some who don't agree on process, some who agree on fundamentals, and some who disagree on fundamentals. That's okay. But what is really important is that we recognize the 2 points that I've made. One, I think the current system is built so that systemic discrimination will always exist. That's, to me, if you don't accept that, then forget it. You mean I'm not even with you, because everything that I've seen now, like if you even read I'm not sure if it was the Ontario Court of Appeal or the SCC. I think it was the SCC that recently said deferred human rights decision-making to labor boards. And there was a big discussion about whether or not these labor boards are competent or have the jurisdiction. So actually it starts with saying whether they have the jurisdiction, and then really weakly talks about their competency to deal with a human rights violation. And so the norm for the majority of the legal, academics is that the understanding of human rights is almost like, it's like a given, like anybody can understand it. And to me, that is a very naive way to look at the reality of what human rights actually, like a human rights violation. People from all different parts of life, and you can start with even you start with the indigenous experience, you move on to the immigrant experience, then you have changing realities of religion, you have changing realities of gender, you have changing realities of sexuality, you have changing realities of disability. You go through the gambit, and then you realize that you have to be a superstar expert to understand a human rights violation. And the case law, if you can go through any of the case law on human rights and not be perplexed by the depth that you need to go into it, starting with a so-called prima facie case, moving on to the justifications and the counter defenses and all of the constitutional arguments, you get into so much interesting discussions. But there is no way that I would entrust this. That's what I mean. How do you entrust this level of analysis to every institution, and some institutions have zero resources to even have a hearing, let alone consider the nuances of what happens to someone after a human rights violation has occurred. Forget about the fact of, like, they won't even, like, many of them won't even pass the threshold of saying, oh, this is a prima facie case. Like, I know for a fact, and I said this at the Law Society of Alberta when they were doing the experience project that was shared with everybody, and it was like, this is just the tip of the iceberg of the experience that we all have. So I'm not, like, I do want everyone to be involved in human rights, but I don't want people to make arguments that somehow they're the only ones that can deal with it. And two, never face the fact that we have this systemic discrimination that overrides pretty much any sort of hope that an institution will do it. So the second part that I'm saying is that this network, if we want a benefit of the network, that network must create its own legal system and then create policy, affect legislation, get public resources, and focus on the victims. I've always said that human rights and you know, they have fancy words when they're saying, oh, you know, human rights is moving toward restorative justice, but really that was a buzzword for we're going to put more money into another type of institution, and we're just going to pretend we're going to do more for the end user, i.e. the complainant. And that actually, you know, there's studies done on what was the effect of us focusing on restorative justice or the victim. So this topic that we're talking about is so important in the sense that everybody must ask themselves the question, if we are going to get together as a network of legal professionals, we, one, have to recognize that systemic discrimination, we have to figure out how to destroy it. And two, we have to then we have to create a new legal system that benefits just the victim. And I don't care if it means we give them, you know, everybody gets $10, right? Like something stupid like that. But we will then highlight what happened. We will, like, you could have so much benefit from people knowing that this conversation is happening and can be engaged. The fact of the matter is that it's going to be difficult because people are going to try to use fake academic arguments against a legal system. They're going to say, oh no, it's good, we have the court system, we have the Human Rights Commission, we have occupational health and safety, we have the bylaw enforcement, they're going to try to dissuade you. But for me, all of that shows that we need something a bit more concrete, in which those like John Humphrey's, the JSC, other institutions feel more of a participation. And that is the benefit of such a network, because all of us deal with individuals or institutions that are trying to make a difference. And I can see Renee is saying, we don't feel included at all. Without JHC, I would not even, my reality of human rights wouldn't even exist. I'll tell you that right now. Without Professor Gall, I wouldn't have been even thinking about this. I'd be doing something else. So that's where we need to focus on the benefit of this network. And it's with the work that JHC is doing, and like everybody who comes to JHC needs to know that there is this network of legal professionals that will jump in and will help. I guess the thing is that I know that sometimes we can't do everything for that individual, but we can start to develop our own competencies and capacities and expertise that we can then go out and make sure that when they come to our network, which it has to include John Humphreys and other groups, they will know, holy moly, this is a massive, this is a movement. This is bigger than the Million Man March, right? That's what everyone has to feel, because that's how big it has to be. because it's not just about one community, it's about all communities coming together and all legal professionals who really want to make a difference for that victim. So that's how I feel about building this network. And look, I already feel more, I always knew Robert, but now I know Jeffrey and Lisa, and if they call me, or I'm going to call them, I'm going to bring them to my next, when I'm on the street corner with my soapbox and my speakerphone, or whatever, my speaker, I'm going to call them to come along. They don't have to, but I'll feel comfortable reaching out to them. So that's what I want to say.
Thank you, Armand. Robert, if you would like to go next. And I think I also just want to add in as well, how can we further develop and reach out to lawyers to engage them really? Because I know that is an issue in terms of getting paid, and time is money, and working pro bono. How can we engage with especially new lawyers? I think if they're coming right out of law school and they have a lot of debt, and I know that's something that was a barrier for a lot of even my peers in engaging in this work, was really just the reality of their situation. So I'd like to just tack that on to the main one as well too.
So with what I talked about with the processes that I've started, I'm trying to address these issues. So for me, and it was mentioned earlier on by Lisa, I mean, Lisa said at the beginning, it costs money, it costs time, right, for the lawyers. And so what has to happen is the work has to be profitable. For the number of victims of hate crimes that there are, I don't think there's enough lawyers that are just kind-hearted enough to want to do the work. You're going to have to, this has to be economically viable for lawyers for this to be effective, in my view. And so that's why I started with this advanced costs idea. So, or legal aid. You have to have a mechanism to pay the lawyers. So as I said, I'm trying to get the advanced costs for this class action. If I can force the government to pay legal fees for all the victims of child welfare, then those victims will be able to hire their own lawyers, because I can't do all these cases. There's over 10,000 cases probably. And so what's going to happen is a mechanism for them to get paid, and not necessarily on a contingency, because if it's on a contingency, there's always motivation for the lawyers to, take a lowball offer so that the lawyer makes the most money per hour. And that's not in the interest of the victim. And so if the government has to pay the lawyers on an hourly basis, I think that is the most effective way of getting proper legal representation for the victim. So that's one thing. Now, I actually have just recently come across a law firm that has agreed to start working with me to help the child welfare victims to sue. And actually the firm is Diamond and Diamond, who's from Toronto, and they're opening up an office in Alberta and I think in BC. And so they think that they can do these lawsuits economically. Now, I don't know if it's possible right now without advanced costs. They seem to think it might be possible. And the difference is, from their perspective, I've told them I don't think it's economically viable because they've tried to put me out of business. And, I had a case where a child welfare boy was brain injured when he was 1 year old in the year 2000. And that case just settled this summer. And the government had to pay $3 million. It took 20 years. So our legal system allowed the government to delay the case for 20 years. So if they can do that, I don't see how, any firm can wait 20 years before they start getting paid. Now, this for like Diamond and Diamond says they're big enough so that they have the resources, they have incoming, streams of profit, so that the government can't try to bankrupt them as they tried to bankrupt me. So, if it's economical, they'll be able to do that. And the benefit of such a network is that these issues are very complex, just as Armand has been pointing out. It's very complex issues. You need lawyers that are trained in the law and trained in this area, because even if you just get a lawyer, they might not have the expertise to deal with the intricate issues of human rights. And so I think that groups like John Humphrey, I just have so much respect for them doing all the work that they do. And I didn't know, Praveen, that you were a lawyer with them. So I didn't know that they had some legal expertise with the group, with the organization. But to be able to do that work as lay people is just it's just so difficult. And so I really admire groups like John Humphrey for trying to do that work. But it is, really, this kind of work requires so much expertise that you really need lawyers at least overseeing and providing, advice and guidance. And it's only when you get to that level that the victims will truly get what they're entitled to. Because if you have people that are lesser trained, they might be able to get some remedy for the victims, but probably not the full thing that they're entitled to.
Yes, absolutely. Thank you, Robert. I think that's also just the benefit as well of these hosting these events, is to be able to network and meet other legal professionals and like-minded people that really do want to at least try to overturn the system in whatever way that we can. So thank you, Robert, for sharing your insights. And Jeffrey, if you would like to go next.
Yeah, I think my comments are going to be pretty small, as much as, so first of all, to echo your sentiment, the idea of events like these being really important to just building networks of people and recognizing that there are sort of like-minded people interested in these issues and in engaging on these issues, I think is super important. I think my call or my comments are going to seem really restrained in light of Armand's call for a new legal system. I love the radical energy. Like I live for it. This also is in light of what Renee said at the beginning. She wanted us to think radically, and unfortunately, maybe it's just being a lifetime public servant, working in the with the machinery of government at a glacial pace. I guess my comments are going to seem really restrained compared to those, so I apologize in advance. I guess my biggest comment is going to be in relation to potentially the development of an approved legal service provider through the Law Society, where lawyers, particularly government and corporate lawyers working in remote Alberta areas, are able to engage with clients on a pro bono basis. So I know, where mainly Crown attorneys out in the middle of nowhere, and I know there's a number of regulations around what they're able to do and the kind of pro bono work they can engage in, but a big barrier for me as a corporate government lawyer registered with the Law Society is finding an approved legal services provider to sort of practice in. And thank you, Armand. I I work downtown, so maybe I'll join you. I will, let me know the time and place. So, you know, while I recognize, you know, for example, the small town lawyers really operate in a super small economy, and generating pro bono interest in those super small economies can be really challenging. I think that there are a lot of missed opportunities in engaging lawyers who are restricted because of our insurance from actually engaging on these pro bono issues. So for lawyers who aren't aware, or for people who aren't aware, we pay our dues to the Law Society in two parts, as the registration as a lawyer and our insurance. Corporate government lawyers don't pay the insurance part because we're insured by our employer. So, but we're able to engage in pro bono work with an approved legal services provider, and only within whatever scope that ALSP sort of gives us. So when I volunteer with the ECLC, for example, you know, I'm providing summary legal advice. I'm not really able to carry files the way that a lawyer in private practice can, where they meet a client and they're like, oh, you know, like your case just really tugs at my heartstrings. I'm going to bring it home with me, and I'm going to carry this forward. We don't really have that same capacity because of insurance. So I think that is sort of going to be my biggest contribution to the conversation, in that having an ALSP that is able to sort of generate opportunities for lawyers who are really passionate about human rights practice and want to, for example, in one case, it involved a queer man and his partner in a small Alberta town. I think the case is reported in 2020, I think it was, or no, sorry, 2018 it would have been. The facts escape me, but this person was looking for a pro bono lawyer, and there is a dearth of pro bono lawyers in rural Alberta. So I make this comment in light of the report that was shared. I took a quick look at the stats there, and it's like, well, do we just think hate incidents are not happening in Jasper or Hinton, where I grew up? You know, no, I think they are happening. They're just underreported, and we don't, you know, as few mechanisms as might exist in Edmonton or Calgary to deal with these. They're completely absent in these small towns. So yeah, so that's I don't know if those comments are helpful or not, but I think, you know, going back to the radical, the invitation to think radically, I think, you know, generating a more formalized network of lawyers, particularly, you know, in small towns, has this potential to sort of generate interest in sort of every corner. And sorry, I'm rambling on now, but those are my comments.
Thank you, Jeffrey. Now I'm just taking in what you've all said now, and I think, you know, Armand and Jeffrey as well have touched upon, you know, almost overturning the current system. And we've discussed this at JHC a lot, how the current legal and justice system is really rooted in a colonial legal framework, both the civil and common law. And it is something that I know that there is a movement now towards integrating and implementing other legal perspectives such as Indigenous practices or restorative justice practices, but I do think that it is very difficult to as they are so deeply rooted in our current justice system. But Renee and I we're also just mentioning as well that in our chats to each other that currently right now JHC is undertaking research to examine the federal human rights mechanism, the Canadian Human Rights Commission, in order to identify barriers that complainants experience as they move through the process. And we just recently presented at a conference, and we are drafting a report, and really what we want to do is to identify these barriers and offer concrete and tangible recommendations in order to attempt to dismantle these barriers. And our hope is to also then, once we are finished at the federal level, to really move to the provincial level and examine the Alberta Human Rights Commission. So there still is a really long way to go, but I would love to speak with all of you as well regarding this research project. Yes, and it is really we're examining it from the user experience, looking at it from a legislative lens, the administrative lens. We intend to do a budget analysis as well, looking at the resource distribution. So yes, yeah.